Hello and welcome to Legally Speaking with me, Tarun Nangia. We're going to today discuss bails, also issues concerning bails and predicaments after the Vijay Madanlal Chaudhary judgment, also how various courts are taking a view after the judgment, and allied issues. Bail is not only a matter of liberty, but many times is essential for promoters to run their businesses. In India, businesses are promoter driven, largely so. We will discuss all that and more. I have somebody who does these cases on a day-to-day basis in the courts of law. I want to welcome Advocate Malak Bhatt. He's founding partner of NM Law Chambers. Good to see you, Mr. Bhatt, and looking forward to some interesting insights from you on this really interesting topic.
Thanks, Arun. Always a pleasure to be back.
And at the outset, can you share with the viewers the status after of bails in the light of Vijay Madanlal Chaudhary judgment and the opinions that courts have taken after the judgment? If you could reflect on that in a detailed manner.
Sure. So let's break this down in two parts. One is what is happening in the courts after the judgment of Vijay Madanlal came in. For the viewers who need a bit of a background, this is the judgment where the vires of various provisions of the PMLA, as they stand after two amendments that took place to the Act, were challenged before the Supreme Court by way of various writ petitions. And the Supreme Court decided the writ petition in favor of the ED, where the vires of all the provisions within the PMLA, as they stand after the amendment, were upheld, where the courts found it that this is a move in light of India's international obligations, in light of its in the conventions that it has signed towards anti-terrorism, anti-money laundering, and the protocols that it had signed towards these international obligations, and obviously read in various rights within the Constitution of India to say that all these rights are duly factored in when the PMLA is promulgated the way it is. Now, as far as the judgment is concerned, this was a judgment given in July of 2022 by a three-judge bench member of the Supreme Court. And pursuant to that, two or three, I would say, interesting and divergent views or opinions have taken place in the Supreme Court. So after this judgment was pronounced, one of the first things that took place was there was an immediate review that was filed by various parties before the Supreme Court, saying that, look, a lot of arguments which were raised by the parties, including the fact that the provisions are clearly in violation of not only fundamental rights, but also of basic humanitarian rights, which are read into our Constitution, are not being taken into consideration. For example, the bare minimum requirement of providing a copy of the ECIR, or which is typically the fundamental document on the basis of which ED starts an investigation, is not provided to the accused, to the agreed persons. The Supreme Court held that, well, it's an internal document and therefore need not be given. And that was the first striking gun that the review court also took it up. So the first thing that really came to court was that the review was filed. It was listed before the open court, which itself is the first step of the review process before the Supreme Court. And once the review was filed, the court has issued notice saying that there are various issues which need reconsideration as far as Vijay Madanlal is concerned. Now, this batch of review petitions today is pending before the Supreme Court for consideration. It will, I'm guessing, in due course be listed. But that obviously will be the judgment, a three-judge bench member, again, sitting to decide whether the judgment requires to be reconsidered or not. And we have to keep in mind that out of the three judges who gave the judgment, today two of them have retired. Justice Khanvilkar and Justice Dinesh Maheshwari are no longer part of the bench. So it will obviously be a new court, two new fresh of eyes who will be looking at this judgment from a different perspective. Now, interestingly, what happened is that after this judgment came up, and while the review was pending, two other matters took place before the Supreme Court. In a batch of writ petitions which came up before a three-judge bench of Justice Kaul, again, a substantive challenge to certain provisions of the PMLA was raised, which is specifically Section 50 and Section 63 of the PMLA, which give the ED the power to record your statement as evidence on oath, and these statements become admissible in the court of law, which is very peculiar to the facts of an ED investigation, because as a police investigation, what typically happens is that the statement you give to the police is not considered to be admissible in oath. It has to be proved in a court of law. Contrary to that, a statement under Section 50 of the PMLA becomes directly admissible in court and can be read against the accused itself. So this challenge was brought in before Justice Call. One of the grounds raised in the petition categorically was that, look, we know Vijay Madanlal holds Section 50 to be valid. However, there are ABC reasons which have not been considered by this judgment. And therefore, very interestingly, and as a very nuanced way of bringing a petition to the court of law, it has invoked Article 145, subclause 3 of the Constitution of India by saying that, look, this matter is a substantial question of law, which generates an important question which the court has to consider only in a larger bench. So in effect, the petitions which are pending before Justice Call, which in a 3-judge bench, has specifically sought as a prayer a reference of the Vijay Madanlal Chaudhary to a larger bench, which would be a constitution bench of 5 judges. And that petition today is also under consideration, likely to come up in July. And my sense is that somewhere between the review petition and this petition, there will have to be some cohesiveness to actually consider all these questions together so that there's no conflict. In the meantime, what happened recently, and this is just about a month back, is that a 2-judge bench of Justice Krishna Murari and Justice Ramasubramaniam refused to refer Vijay Madanlal to a larger bench. Now, obviously, it created uproar. It created a lot of tension and turmoil amongst a lot of promoters, a lot of business people who are facing ED investigations that, oh, that's the end of the process as far as referring Vijay Madanlal forward is concerned. But that may not be so, because if you see the reasoning given by Krishna Murari, is that he was sitting in a division bench of 2 judges, and therefore he said that, look, I as a 2-judge bench of the Supreme Court cannot, probably in light of the rule of stare decisis, the rule of judicial propriety, refer a judgment which is given by 3 judges to a larger bench. Let that be decided by an appropriate court. So he's probably left it at that. But I feel that these 2 pendencies of the review and the 3-judge bench reference are very important factors that today will drive the course of how PMLA will ultimately be read for all the provisions.
Mr. Bhatt, 2 things. Promoters from across the world are eyeing bails post Vijay Madanlal Chaudhary. I want to understand from you that the worry is not in the promoter who is already been booked in a PMLA case. The worry is of many people who feel that today or tomorrow they might be booked. Innocent or not, sometimes transactions are questioned. People have to go through an investigation. They may be acquitted, but they fear incarceration before acquittal. That, on mere allegation, they will be spending 1 year in jail or 2 years in jail.
No, absolutely. And Tarun, bail remains a very longing and very serious concern as far as ED is concerned, because the fact that the Supreme Court today has given a clean chit and a stamp of authority to Section 45 of the PMLA, which in common parlance is known as the twin conditions of bail, where they have actually set aside the judgment in Nikesh Tarachand and said that, yes, the twin conditions as they stand today are valid, definitely creates a atmosphere of fear, because the fact that if you're today arrested by the ED authorities under a PMLA case, you have to meet a larger threshold to get bail is definitely there. But I will also here err on the side of caution and show a ray of hope, is that Vijay Madanlal to that extent has also various observations, various findings, and various ratio decidendi which create enough legroom for accused persons to try and obviate from that risk and be able to argue bails in a manner to show that, look, I don't have to meet the threshold of going to show that I am not guilty. And in fact, that to that extent, the Vijay Madanlal judgment is so beautifully drafted that it caters to the need of the ED as well as to the accused. And various high courts we have seen recently have started using that threshold to say that, yes, it does not mean that I have to be shown to be not guilty. Prima facie, if I am able to satisfy that this is a case where I have a benefit of doubt which can be read in my favor, bails will be granted. And I can off the cuff give you at least examples of 3 or 4 high courts where courts have used the various tests laid down in the Vijay Madanlal judgment to grant bails, regular bails, in cases which came up before them. Illustratively, for example, Delhi High Court recently has given 2 or 3 judgments where one they have said it is not beyond reasonable doubt, it is slightly more than prima facie, but that can be satisfied if you are able to, as a promoter, show that look, either the evidence is collected and that there is some loophole in the evidence, or that there is a positive interpretation that the documents or the evidence can be given to in your favor. Number 2, the manner in which the investigation has taken place. Various times you've seen Delhi High Court grant bail on the condition that it seems that the investigation has been conducted in a very mechanical manner where all the statements of all the people being read against you are the same. Number 3, cases where there are only statements against you because the ED would have nipped the people, asked them to give statement, but there is no documentary evidence to support that. So today, to that extent, the requirement of these statements which are otherwise admissible in court to be the sole test to find a presumption of guilt against someone is also reduced. Then there are cases where the predicate offense is not something grave, and the court has actually come to a conclusion that yes, the predicate offense itself seems to be at a stage where the ED could not possibly have come to a conclusion that there is money laundering. Say, for example, there is a case where the complaint or the charge sheet is filed under 420 read with some other offenses which are not predicate offense. 420 is one of the predicate offense, but the court decides that no, I am not going to take cognizance on 420. I'll take cognizance only on the other offenses. In such cases also, high courts have come to the rescue of people to say, sorry, these are cases where ED at least could not even have come to a finding of guilt or a finding of any culpability of under section 3 or 4 of the PMLA. So grant the benefit of bail. So, there have been cases where nuanced arguments have been raised, have been countered, yet have been appreciated by the high courts to ultimately save the liberty of the accused. And therefore, I feel that we are not yet in a situation which is completely grim. There are cases which will definitely be considered in light of Vijay Madanlal Chaudhary as it stands, that bail can be granted, will be granted, to the extent it is not a case of absolute guilt which can be proven from the record before the court.
I'll take this issue further. When you deal with a lot of these businessmen and promoters who are accused, when you represent them, do you feel that they have this fear of attachment or possession of assets? Because that is a worry that looms large many times. Also, the worry that sometimes there is a huge portion of assets which are attached. Could you just decode this for the viewer and the common businessman, because he needs to understand this issue?
Yes. So the scheme of how the PMLA works is twofold. There are 2 parallel proceedings that take place under the Act. One is the proceeding which is the criminal prosecution, where the investigating agency, the ED, conducts the investigation and ultimately goes and files a complaint against the person who is then prosecuted as an accused. The second, obviously, is because ultimately the aim of the Act was not only to prevent and deter, but also to gain back the proceeds of crime, which is the ill-gotten wealth or the tainted money, as we call it. That proceeding is by way of attaching the assets which the ED identifies and recognizes as what is called a proceed of crime. So as part of the investigation, let's take the most basic example. There's a case of cheating, a bank fraud. That money is taken out, siphoned into someone's personal account. From that personal account, loans are given to your known people, your known employees, and those people ultimately go and say, buy a house. So today, as part of the ED's investigation, they would have identified that that particular house is the proceed of crime, because that's the channel through which the tainted money is tried to be shown as untainted money. And that's the power that the ED has under the Act to go and attach that property, so that no third party rights are created. And at the end of the trial process, if one is to be convicted, then that property can be confiscated to recompensate the exchequer, the lost cost of the exchequer. Very interestingly, the Act actually provided safeguards initially to the extent that the attachment power should only start at the time when the final report is filed. So only when a charge sheet or a complaint is filed by the ED should the ED start the process of attachment. Later on, the amendment was brought in because it was felt that if one is to wait till the outcome of the investigation, then a lot of the assets would anyway be dissipated and there'll be nothing left in the hand. So the ED's powers were enlarged to say that you can start the attachment proceeding as soon as possible. However, you will have to meet the safeguards of filing a complaint immediately, the fact that the attachment will lapse within 180 days if it is not confirmed. There will be an appellate provision tribunal. You will have to show that this is actually a proceed of crime. So those safeguards were built in. Now, the fear that is there today, and rightly so, is that in most cases, what the ED does is the moment they come in, the moment an ECIR is registered and investigation starts, whatever list of assets they are identified or are provided to them immediately get attached as a provisional measure to ensure that no third party rights are created or no further dissipation takes place. Now, with this, what is happening is that ultimately these are assets which belong to the corporate infrastructure of the company. The moment these assets start getting attached, there are various other stakeholders who get affected, like banks, like people who have actually created charge over these assets. The fact that these assets may ultimately be operationalized in some other project, in some other infrastructural financing needs, is something that today the Indian economy is not able to fathom, which is why we are seeing a lot of, for example, a lot of IBC cases where the company is actually undergoing a very strong resolution framework. The IBC is working towards trying to garner and cater to the debts of banks. But since the assets are already attached by the ED, the banks are trying to take a foot back, saying, why should we go into IBC when ultimately nothing's going to come into the hand? Now, my 2 points of submission and my two takeaways from this process is that in one way, Vijay Madanlal over here has come into the rescue to the extent of saying that, yes, the process of under section 5 and 8 of the PMLA may be correct. However, the ED should not go and run to take possession of these properties the moment there is an attachment. It says that attachment is only an art of signifying that, yes, there is a right or some kind of an interest that the ED has created on the property, and the asset is not free of encumbrances. However, it still remains the asset of the accused person, of the person who is aggrieved. And no one should run to take possession of that unless there is an imminent threat that the asset will be dissipated. And this, I'll tell you why it's helping, is because typically before Vijay Madanlal cases, what we used to see was that the moment there is an attachment which is confirmed by the adjudicating authority, 3 days later, there would be an eviction notice sent or a possession notice sent by the ED saying kindly vacate. Now, typically you have a 60-day period to challenge the adjudicating authority's order before the PMLA. But practically, so what used to happen is you used to be in PMLA on the 7th or 8th day, because you will have a notice from the ED saying kindly vacate within 10 days. And you would be running to get a stay of that notice. That at least has to my understanding and my limited experience, if not completely stopped, tapered down to a majority extent. And that is actually helping a lot of business houses, promoters, stakeholders to ensure that even if there's an attachment, their legal recourse will be taken care of without the asset actually going out of their hand. But the second part of that, which is my fear arising out of this, is that large amount of attachment standing for a very long period of time is also not very good for the economy as a whole. Because what happens is that assets which are otherwise free from encumbrances allowed to be traded, or assets which are otherwise exchangeable, become part of the movable assets of the country as a whole, not just in the hands of these corporate houses, because these are assets which are functional assets as part of the growing economic infrastructure. And the fact that the attachments are today more than the substantial value of the actual crime being committed is something which ultimately Supreme Court will have to look at. That is this really working in the economic interest of the country?
You've raised a beautiful point. It goes without saying that anytime an attachment is made, it's made at book value and not at market value.
Absolutely.
And that is causing a lot of problem to the promoter, because many times assets far in excess of the allegation are attached. Secondly, we have also seen recently that assets not created from proceeds of crime happen to be attached. Do you think that also needs to be looked into by the courts of law, or the ED itself will also look into these things?
See, that brings me to a very interesting point, which again Vijay Madanlal touches upon. You're absolutely right. It has to, in fact, ED needs to have a relook at this issue, and I'll tell you why. The amendment which was brought in to section 3 and section 2(1)(u), which defines proceeds of crime, talks about the very fact that that property identified will be a proceed of crime, and at the end adds words or the value thereof. So what the ED started doing and using umbrage under this huge definition is that they said, okay, fine, if I can't identify that particular asset, I will identify the value of that asset and attach every other asset to come up to that value. What is happening because of that is that various assets which otherwise would not have fallen within the definition of proceed of crime are also getting attached for the lack of ED's investigating capabilities of actually going and identifying the attached. Let me give you a very nice example over here, which is also a live example. Real estate companies, which typically come under ED investigations, have assets which are belonging to the promoters, which may or may not add up to the value of the actual crime that they're trying to investigate. Let's say they're saying that there is a siphoning of 1,000 crores. Now, the asset belonging to the promoters directly will only be about 80-90 crores as per book value, as you said. Now, what they do is they will try and look at the books of the company under question and attach assets which may not even belong to the company, or which have gone out of the company's hands, or belong to third parties, because they recognize that this will become ultimately a part of the crime. And the people who actually suffer in examples like this, let's say a real estate company, are the home buyers. Because if ED is to go and attach an entire tower or an entire project, there will be units in cases like this which are actually sold to third parties, where people are actually going and staying, where sale deeds are registered, but today they have an ED attachment being faced against them, so they can't sell it further. The people who are actually suffering is the citizen of the country. And this is just one example. You'll have for an EPC company, you have an example like this. For an infrastructure company, you have an example like this. For a company dealing in power projects, you have examples like this. So this is a very rampant problem which is spread. Now, the fallback to this is again found in Vijay Madanlal to the extent possible. And again, this is an argument which is today being tested in court. So I'm privy to that. Is that one aspect that Vijay Madanlal was considering was the requirement of there being a predicate offense in the first place. So the judgment says that if there is no predicate offense, or if the predicate offense is closed or stayed, or has ultimately not resulted in a charge sheet being filed, then ED's investigating powers get circumscribed to that extent. So recently, the Delhi High Court on an issue like this gave a judgment that, look, if the investigation in the predicate offense is qua allegation A, and the assets which loosely can be categorized under allegations which fall under allegation B, the ED has no power to deal with assets under this, because this is not part of the predicate offense. And this is a beautiful judgment that Yashwant Verma had given from Delhi High Court, that your powers today have to be read within the umbrella of a predicate offense. You cannot go and start pointing your finger to every asset and start attaching it to say, oh, everything that was being dealt with by this particular person who today is an accused will definitely be a proceed of crime. Your powers have to be then read towards only those properties which typically were created from that particular scheduled offense. And that, I feel, is a very, very important takeaway from Vijay Madanlal, because that, interestingly, that observation came in the light of whether ED can continue a criminal investigation or not. But the fact that today that is being used by high courts to say, look, sorry, your investigating powers for attachment also have to be read under that umbrella is a very positive, emboldening step that the high courts have taken. And this is not just Delhi High Court. There are other high courts also who've also taken similar views.
Point very well taken. Today we discussed a very good number of set of points that, in the sense, the business and the promoter community seem to be studying or know about. Of course, bails were discussed, possession attachment were discussed. You also spoke about ECIR. This whole issue of valuation of attachment is very interesting, because it impacts a large number of promoters. What also remains to be discussed is, if you could quickly comment on the ability of the accused to get a copy of the ECIR. Do you see that happening anytime soon?
So interestingly, while I was part of the review committee, the review hearing which took place before the Supreme Court, and this is the time when Justice Ramanna was part of the first bench where the review hearing had taken place. And before even the accused or the lawyers for the petitioners could actually come up and commence their arguments, the first comment that fell from Justice Ramanna was that we've seen through the petitions, and I think that one of the first issues which will definitely have to be reconsidered is the fact that ECIR is not being given under the present judgment. And if he felt that that is one issue which will definitely have to be considered. So I believe that's a very positive takeaway. And we have practically seen cases where if one goes and petitions the court, at least the lower courts, to say that, look, now that there is a complaint filed against me, cognizance will be taken. The complaint obviously will carry the larger part of the allegations against me, but ECIR is something which is the fulcrum of how it started. Give me a copy. In most cases, we've also seen the ED succumb to the court and say, yes, we will provide a copy. So I do feel that in future, you will have a situation where at least the ECIR will definitely have to be given, like a copy of the FIR is readily available.
Point very well taken. A large number of questions were addressed today. Some questions, some anecdotes need to be shared. Some questions remained unanswered because it's a vast subject. I think we'll have to do a follow-up on this one. But today, I think a lot of doubts were cleared. Many anecdotes were presented. Of course, the whole issue of bail, attachment, possession, ECIR remains, in a sense, much debated in business circles in India. That was a reason for taking it up. And we'll follow it up with you as the review petition also is likely to come up soon. Appreciate your joining us and sharing time, explaining things in detail. I also hope the viewers enjoyed it as much. Thank you so much for your time.
Thanks a lot.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.